Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Kimberly Wong, Head of Litigation at Coopers, we will be discussing laying the groundwork for a successful mediation. Before we get into today's topic, a few words about Coopers LLP. We at Coopers are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome back to the show, Kimberly.
Thank you for having me.
So today we're talking about making sure that a case is actually ripe for mediation. Have you had experiences where a case is not ripe but still headed down the track to mediation?
Sometimes the timing is not always within our control. Sometimes we mediate because the court requires us to mediate by a particular date, even though that time frame is not right for that particular case.
In that regard, have you had any cases recently in the past where you have been put in a position where you know, both sides know, that you're being forced down a mediation track before there's really any chance that there will be resolution?
Yes, one case comes to mind. It was in federal court. It was a judge-specific deadline where he had a standing order that every case go to ADR within 90 days of the first CMC. And we hadn't even started discovery yet.
How did you handle that?
Well, both the defense counsel and I were in agreement that that was too premature, especially for this case, which involved a product liability claim with catastrophic injuries. We conveyed to the judge at the CMC that for this kind of case, we're probably going to have a dozen experts. Liability is contested. We need to do discovery to figure out the liability issues. We don't even know much about the product at this stage. And on top of it, the client's prognosis and future care needs and damages will require the work of consultants, a defense medical exam, and there's no point to a 90-day ADR. We aren't going to be able to talk numbers without additional information.
Were you able to reach the point where you could get it reset in a way where it was meaningful? Or, there's that old judge joke, the difference between God and a federal judge.
I've heard it. I don't remember the punchline.
God doesn't think he's a federal judge. To all you federal judges out there listening, I apologize. Were you able to convince the judge that this was not the way to go?
Well, we got the 90-day deadline pushed back, but it still isn't pushed back far enough. So that was a case where we ended up having to do 2 mediations for the sake of doing 2 mediations.
And that sometimes happens. And that's why we're talking a little bit about trying to make sure that all the groundwork is done so that the mediation is ripe as opposed to not being ripe. You did a long list as you were talking about the things that needed to be done before that case was ready to be able to mediate. When one is either being pushed to mediation or even if not being pushed, it's been set. Are there things that you do in talking to defense counsel to make sure that they have all the information far enough in advance for the mediation to actually be ripe?
Yes, definitely when you are scheduling a mediation, when you're figuring out what the time frame is, you want to make sure that both sides have the information that they need. And so hopefully you've had this conversation with defense counsel before you get to the point of we're a couple of months out from when we would like to mediate. But yes, there's some things I want to know is how soon do you need my demand or mediation brief? I usually will assume as a default that 30 days is going to be enough, 30 days before the mediation. But on occasion, some have told me they prefer a little bit more time. They might need 6 weeks. And so I want to be aware of that because if you're going to set your mediation up for success, if they don't have the authority because they have some crazy decision-making process where it has to go through 20 people and it goes through 6 rounds, you need to know that.
At the risk of a tangent, but not too much of one, What types of cases have you had where defense counsel says it's going to take 6 weeks as opposed to 4?
I honestly don't remember the specific cases, or I just understood it was their insurance adjuster. That's their process.
Okay. I was wondering if there were certain patterns like, 1 layer of excess, 2 layers of excess, or some complicated self-insured that made it where you're more likely to need more time.
In my experience, what I've seen is it really depends on the insurance company and their own processes. Like sometimes, and that's what I want to find out from them, whatever they're willing to share, is how many people are decision makers, how many rounds of decision making need to happen before they get authority to make an offer, because and then you work backwards on the time.
I presume then that same type of entity is going to need things like defense medicals or plaintiff's depositions or what have you also that far out.
Yes. They expect to have the full demand package, the full information about liability and damages, at least that far out.
As you're trying to make sure that the mediation is right, do you talk with defense counsel or the various defense counsel and multi-party about coverage issues and making sure that there's no lingering reservation of rights?
Yes. And in cases where there's indemnity agreements in the contracts and everyone has their own insurance and there's questions of how do the insurance stack, who goes first, who goes next, that is often a roadblock that I want to make sure that they've started the conversation about to the extent possible and resolving ahead of time.
And is that something that you do yourself, or do you sometimes work with a mediator to make sure that the proper questions are being asked well in advance?
I do. I've done both. I definitely want to hear it myself from defense counsel, whatever they're willing to share. If we've already agreed on a mediator and there's a good amount of time, in one situation that I can recall, I recommended to the mediators, like, can you sell them on doing a 2-session mediation? The first session is just amongst the defendants to figure out their insurance issues and what they're going to do. And then we'll come to the table on the second session when they've figured that out.
Out of curiosity, what time frame between the first session and second session did you have those staggered?
I've offered or suggested this on several occasions. It doesn't always work. They don't always buy in on it. But really, they are the best ones to tell us how much time they need to figure it out if they are game for it. So it may be a period of, a month or a few months in between, because as I don't know what your experience is, it usually is not an easy decision. And then actually a lot of cases too, what I've had happen is we get to the point where there's enough pressure of the trial date that they don't figure it out, but they agree on the global settlement amount and they figure it out after the fact. And that's something that we would suggest too. Like, can we agree on an amount and then you guys work it out later? We gave you this opportunity to try to figure out earlier, but you guys didn't want to. So now you have your choice of heading to trial, which we're prepared for, or you can just figure it out on your own after.
I like that pressure posture. I find that oftentimes one can get a better result when people have not determined that it is truly their money. It ends up being somewhat tense though, because those like you, I find that typically happens in that week before trial when everything's fast and furious and it's a follow-up from the settlement conference or the diligent mediator. It's not happening in the mediation itself, whether it is first session or second session. As we talk about ripeness, when you're making decisions about ripeness, do you think about things like whether you're doing a half-day or full-day mediation?
Yes. It used to be that it was a matter of course that I would do full-day mediations because that's just the default. And then, I don't know, over time, half-day mediations just seem to work well for a lot of cases.
Can you give some parameters for cases where you've seen that be more successful?
Half-day mediations are probably better for cases where there are not a lot of parties. The issues are more straightforward, so you can get a lot done in a short period of time. I would also agree to a half-day mediation on those cases where I think mediation's probably not ripe yet, but we have to go anyway. And then there are other cases where I would agree to a half-day mediation in more complicated cases because the short time that's available puts pressure on the parties to really just get to the heart of the issue. Let's exchange numbers. I hate waiting an hour just for the first offer. You should have an offer ready to go when we show up because you've had our demand for a whole month.
That makes sense. And I won't do justice to the precise phrase, but project will take the amount of time allotted. And if you have a half-day mediation, then you will get it done in a half day if you're going to get it done.
Right. I mean, once you start exchanging numbers, you're going to see, are we getting there or not? Because if you selected the right mediator, the mediator will follow up and close the gap after that day.
Are there situations where even though you may have determined it's ripe, you go in knowing that this is likely to be a 2-session mediation? One day where some things are done and then it's not going to get done that day, but a further one down the road.
Some cases are definitely like that. I think a good example are cases where there are multiple defendants with different liability theories. So I've had situations where at mediation we settle with one defendant and then we continue on the case with one or more other defendants and then we go to mediation with them again later.
We started talking about getting that brief out early. How do you tackle that in terms of making sure that the brief has everything it needs but isn't delayed in terms of getting out the door? And background, I think a lot of us lawyers, we're control freaks, we're perfectionists, we want everything to be perfect. And oftentimes things will get reviewed multiple times and there will be reasons why, we were supposed to do 6 weeks, but we didn't get this report in. I'm meandering a little bit, but I think you get the flavor of my question.
Well, there's always the option to do 2 briefs. Usually, I think the damages side, that's probably going to be held up because you're waiting on your consultant's report or the economist's final numbers to put in for the damages. And so have that flexibility. The sooner you can give the other side information, the better. So there's different ways you can handle it. You could do an initial liability brief and let them know that the damages side is coming. If you do that, try to give them as much damages information as you can without restricting what the numbers are. So, you build up the expectations of what, maybe you don't give numbers, but you're saying, look, our position is that he's never going to be able to return to work. So they have an idea of how to estimate what the numbers might look like, even though you don't have the specific numbers. And then as soon as your consultant reports or whatever other information you're waiting on are available, you do a supplemental brief.
That seems like a good way to handle it. When you do that, though, do you say, looks like he's not going to be able to return to work. Our napkin math on that is X. We will have a consultant's report, economist's report that will solidify that to give you something closer to shoot for as we get closer.
Yeah, I feel like it's easier to do for the lost earnings capacity or lost earnings. I hesitate a little bit on the life care plan because that's so much more variable. But I will at least give the information I feel comfortable with if I say, I know that there are going to be several surgeries of this kind in the future, so they know like there are going to be expensive items in their life care plan. I will give them whatever I can.
Do you still send out hard copies of mediation briefs?
Some mediators will say in their mediation letter that if it's over a certain number of pages, I want a hard copy sent to this place. And so that's an important piece to find out what your mediator's preference is. But of course, if the defense counsel or their adjuster wants a hard copy, but I have not found that they have wanted one, they just print their own.
I find that one as an old timer who knows that a lot of the people that we work with are paper people. I find that one a little bit of a challenge because we don't really send out hard copies anymore. And yet I know that most of our mediators are of a demographic where they're probably going to have it printed out and prefer it being printed out. Similarly for some of our adjusters. But I just not found a good way around getting my nice, clean, perfectly tabbed copy to folks because most hide behind email these days.
While we're on the topic of print versus electronic, I was just thinking about now that we're doing everything electronically, something to consider when you're doing your briefs, you have so much more freedom in a way that you didn't have before. You can attach video clips. You can think about media.
Tell me about that.
Well, if you have some really great clips from video depositions that you want to highlight, I mean, what paints a better picture than to send that with your brief and demand?
When you do that, and I know that there are ways to embed video into, say, an Adobe document, where as somebody scrolls through your brief, they pass a certain portion and it starts playing through a link within the system. Do you do things like that are more sophisticated? Do you have it as a separate file in terms of giving them a link to a Dropbox file or some other thing? What different approaches have you tried?
I'm not that tech savvy. So it would be part of like a Dropbox, usually referenced in the brief as an exhibit.
You're absolutely right, though. And this goes back to briefs and approaches to persuade. We are limited really only in our imagination in terms of how we provide information to the other side. And one of the things I notice from firms who do it at a higher level is their briefs oftentimes have a lot more embedded material. And by that, I mean, rather than say flip to exhibit 3 for a diagram from the police report, it will have the police report schematic embedded in there. It may even have Google Earth images with pieces laid out. There'll be anatomy illustrations. There will be photos, all within the brief itself. So it's a much more engaging document. And I find it interesting to see other briefs at times where there's nothing in there. It's not interesting. And part of my concern with this is I want to make sure that the other side actually reads and engages with it. And I want to make it easy for them.
Yeah, another tactic that I've heard about other lawyers using, but I haven't done personally myself, which I thought was pretty creative idea, is, again, your creativity is unlimited, right? And so I've heard of other lawyers doing their own presentations. You can do whatever you want. You could do an animation with a voiceover. You can use any of your evidence and just put together a montage and a narrative instead of just being in written form. You can use the power of your voice and the power of your storytelling to convey the same message, to add on to your brief. You still probably want to do a traditional brief too.
Yeah, and it's interesting as we talk about making sure that everything is ripe for the other side. I think about a case years ago where I had an adjuster who I felt was not going to read the material. And I, in essence, approached it by turning the situation into a short story, which I will say I still think is some of the best writing I ever did. And then the flat earth defense lawyer couldn't make heads or tails of it. And I had to turn it back into a traditional brief because they didn't have the things in the places that they needed it to be. So it's a way of saying creative is great, but you still should have a square peg, square hole brief to go along with it.
Yes. And also, I think it's important to remember that your audience is not just defense counsel, it's the insurance adjuster. So defense counsel knows your case pretty well, but the insurance adjuster is getting information fed to them through the lens of the defense counsel. So however you can package your information in your mediation brief or package to the insurance adjuster, like remember, they're hearing things from your perspective directly from you, probably for the first time.
As we think about making sure that the case is ripe, how do you handle the discussion to make sure that the right people are going to be participating?
So that's one of the things you talk about with defense counsel in preparing for mediation. You want to find out, to the extent they're willing to share, who are the decision makers, and are they going to be there at mediation, and in what capacity? Are they going to be on standby, or are they going to actually be there? I will also ask the mediator too, hey, can you call defense counsel before a mediation to find out some of these things? You know, like, are there any issues that are going on that we should know about insurance-wise, or who's going to be there? Make sure all the right people are there.
If you start getting indications that there's something going on with the other side, that they won't have all the right people there, and in terms of trusting your gut, and presuming it's not a court-ordered mediation by a certain date, what steps do you take when that happens?
Well, I would check in with the other side, depending on our relationship, and try to move the mediation until we can get all the right people in the right room. I would be a little frustrated and express that as well. But we have to set up the mediation for success. And that, I think, a good mediator realizes that too. And so they're going to put pressure on defense counsel and say, make it happen. Let's first try to make it happen. Like, what are the barriers, right? And I would have that conversation as well. But if it's an insurmountable barrier for the pre-chosen date, let's pick another date as soon as possible.
As we talk about decision makers, I presume at this point, you've checked in with your client and have some understanding of the client's expectations to make sure that it's not your own client who ends up derailing and making it not ripe for that mediation.
Yes, managing your client's expectations about mediation is crucial, and you're going to want to do that throughout the case. But of course, you're going to get in more detail, one, as you schedule the mediation, and then really on the eve of the mediation, whether it's the week before or the days leading up.
Let's fast forward to the mediation day, and let's presume that despite your best efforts, the mediation is not ripe, that it becomes clear that it's not going to go anywhere. What do you do with that day in order to make it as productive as possible?
I like to check in with the mediator to use their experience and also their special knowledge by being able to be in both rooms as to what might be the best next step. Sometimes it might be a mediator's proposal. Sometimes it might be scheduling another session. Sometimes it might be just the mediator following up between both sides. There are also times where the counsel on both sides feel comfortable enough closing the gap because we've gotten far enough along that we can do it ourselves. And then there are other options too, like 998. There are a lot of different ways you can approach it depending on what's going on at that point.
Have you ever used mediation or mediator to go through and help you, both sides, create a checklist of these are the impediments, these are the things that we need to get ticked off before we can meaningfully come back?
Not a formal checklist, but yes, like I would find out if the defense expressed, we really need to have that summary judgment motion heard before we can offer anything more than this.
Have you had situations where you've heard, we understand your expert is saying X, we don't get it all, we'd like to have an informal conference with your expert, or perhaps do an early disclosure to take a depo, and that would be helpful for us in order to be able to meaningfully put the right number on the table?
Yeah, I'm always open to hearing whatever they need, and depending on the specific situation of our case and how comfortable I feel with doing that, I may be open to that.
Are there other things that you do to help try and make sure that a case is ripe for mediation before one gets to mediation?
And we know we touched on it earlier about making sure that defense counsel has everything they need. I'm reminded of a case I had recently where the defense counsel was eager to go to mediation. I thought the liability and damages were pretty straightforward, but I was surprised still that they didn't feel the need to do my client's deposition or a medical exam before mediation. And that concerned me, because even though it was more straightforward than most cases, I really wanted to make sure that they were going to bring enough money to the table at mediation. And I kept asking over and over again because I wanted the expectations to be managed. And defense counsel assured me that they had enough clarity on everything, that they didn't need it. And reluctantly, we went forward with mediation and we were worlds apart. And I was then told that they needed a medical exam and my client's deposition.
I'm chuckling, and I think your chuckling is, despite all of our best efforts, there's the phrase, you can lead a horse to water, but you can't make them drink. I think almost everyone has had that experience where they haven't done what they need to do, and you push and you push and you push, and you still sometimes find yourself in that situation.
Yes.
Well, Kimberly, thanks again for being here.
Thank you for having me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, suggestions on ways that you help make sure that your case is right for mediation. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. For all of you doing justice out there, happy hunting.